Hello everyone, welcome back to RR Corporates. Now we are discussing on Section 12(8) of Companies Act 2013 regarding default in maintaining the registered office. A very important topic because if default in maintaining registered office, what is the consequences? Is your company maintaining a proper registered office as required under Companies Act 2013? If not, you may be penalized 1,000 rupees per day to 1 lakh. This video will explain section 12 subsection 8, the real consequences of non-compliance and how to stay compliant with the MCA regulations. So don't ignore this simple yet critical requirements. So did you know that just not maintaining a registered office can cost your company 1,000 rupees a very single day? So understand section 12, subsection 8 of Companies Act 2013. This is a real penalty and it starts up quickly. In this video, we'll explain what the loss is and how long you can delay before hitting 1 lakh in fines and how to avoid getting the wrong side of the MCA, so with the penalties. So this section 12 of the Companies Act 2013, what it says. Section 12 says every company must maintain a registered office capable of receiving and acknowledging communication and notices, and display its name and address outside the office on the website and on letterheads and documents. The registered office is not an option and it is a mandatory legal requirement for all companies right from incorporation. After this presentation, I'll take you to MCA website and I'll show you the section, explain in detail. So what happens if you don't comply section 12? Then section 12 subsection 8 talks about the penalty. So if any default is made in complying with this section, so the company and every officer in default shall be liable to penalty of 1,000 rupees per day, during which the default continues, subject to maximum 1 lakh. So penalty for the company is 1,000 per day, maximum 1 lakh. Penalty for each officer in default 1,000 per day, maximum of 1 lakh. So for example, if the company delays for 60 days, the penalty is 60,000. And for every director, again 60,000 rupees. Every officer in default. What are the other risks? Apart from these, what are the other risks of not maintaining registered office? MCA may strike off the company from the register. ROC may strike off the company from the register of ROC. ROC, the company may miss the important and legal communications, company may miss notices. So it may affect even bank account opening, GST registration, and even statutory compliance. So the registered office is your company's legal identity. So don't treat this as a just formality. Neglecting this can lead to mounting penalties and legal consequences. So with this, I'll stop here and I will take you to the official website of Ministry of Corporate Affairs and I will show you the section. I'll explain you in detail. So if you like this video if you learn something new, then subscribe our channel RR Corporates and RR Legal Talks. We have 2 channels for latest updates. If you hit bell icon, so you will not miss any of the latest updates on corporate laws, IBC, NCLT matters, and public issues. So we have RR Corporates and other channel RR Legal Talks. I'll stop here. Then we'll go to official website of MCA. Ministry of Corporate Affairs. MCA.gov.in. This is Ministry of Corporate Affairs. Here click Act, then Companies Act 2013. Then here, come down. Here you can see the chapters. We are talking about chapter 2, incorporation of the company. Then come to section 12. Section 12 talk about the registered office of the company. This is what section 12. Section 12 talks about registered office of the company. And penalty we are discussing now. So if any default is made in complying with the requirements of this section, company and every officer who is in default shall be liable to penalty of 1,000 rupees every day, during which such default continues but not exceeding 1 lakh. 1 lakh is the upper limit. So company is liable to pay 1 lakh limit and each director, every officer default are liable. So anyway, we are discussing section 2. I'll explain you what section 12 says, what is the registered office of the company. So the registered office of the company, there are 8 subsections in 12. In detail, we'll discuss what is the registered office of the company. So section 12, what section 12 says? A company shall, within 30 days of its incorporation and all times thereafter, have a registered office capable of receiving and acknowledging all communications and notices as may be addressed to it. So this is the one important thing, that it should be in a position to, company should be in a position to receive all communications. So the company shall furnish to the registrar verification of registered office within a period of 30 days of its incorporation, such manner as may be prescribed. As may be prescribed means, so every company shall paint or affix its name and address of registered office and keep the same painted or affixed on the outside of the every office or place in which its business is carried out in conspicuous position in legible letters, and if the characters employed in there are not those of the language as one of the local language, general language in that locality, also in the characters of that language are one of those languages. Here it means that, so local language and English, generally what we in practice will keep, so 2 languages will be there. So have its name engraved in legible characters on its seal, if any. The company has any seal, so it is starting that should be engraved in a legible character and gets its name, address of its registered office and the corporate identity number along with the telephone number, fax number, if any, email and website address, if any, painted in all its business letters, bill heads, letter papers, and all its notices and other official publications. This is also talking about how the letterheads will be, all the bill heads, what is required to print on the letter papers and all its notices and other official publications. And have its name printed on the undies, promissory notes, bills of exchange, and such other document as may be prescribed. Provided where the company has changed its name or names during the last 2 years, it shall paint or affix or print, as the case may be, along with its name as the former name. Name so changed during the last 2 years as required under clause A and C. Suppose if there is a name change, so 2 years you have to mention in all the documents as a farmer. Down the name you can write the farmer name also you should mention. You have to maintain for 2 years. If it is a 1% company, shall be mentioned in brackets below the name of such company, where its name is printed, affixed, or engraved as a 1% company. Notice of every change of the situation of the registered office, verified in the manner described after the date of incorporation of the company, shall be given to the ROC within 50 days of the change. If any change is there, change in the situation of registered office, then within 15 days, it has to be intimated to the ROC. So, except on the authority of a special resolution passed by a company, within the local limits, yes, board can change the registered office. Then, if it is beyond the local limits, then out of the city, then the special resolution is members' resolution is required by way of special resolution. See, in the case of an existing company outside the local limits of any city, town, or village, where such office is situated at the commencement of the business, so where it may be situated later by virtue of special resolution passed by the company. If it is changing outside the local limits, then special resolution is required. Any case of any other company outside the local limits of any city, town, villages where such office is in the first situated or where it may be situated later by virtue of special resolution. So even in it is registered in the old act and new act. So if any change in the outside the city or limit, town, village, so then special resolution is required. Within the city, only with the board power, it can be changed and intimated to the ROC within 15 days. Provided that no company shall change the place of registered office from the jurisdiction of registrar to the jurisdiction of the another registrar. One ROC to another ROC, if you are changing the registered office. Or within the same state, unless a change is confirmed by the regional director on an application made in this behalf by the company in the prescribed time. you have to make application for RD. So this communication. So subsection 6 of section 12 talks about the confirmation referred in subsection 5. It shall be communicated within a period of 30 days from the date of receipt of the application by the RD to the company, and the company shall file the confirmation with the ROC within a period of 60 days of the date of confirmation. We shall register the same and then certify the registration within a period of 30 days from the date of filing of such confirmation. So if it is a case, jurisdictional change, we have to coordinate with the ROC and accordingly we have to intimate to the ROC. The order has to be filed with the ROC. So the certificate referred in subsection 6 shall be conclusive evidence, shall all the requirement of all these done with respect to the change of the registered office in pursuance of the subsection 5 has been complied with, and the change shall take effect from the date of the certificate. As we said, no, RD will issue the certificate. Then if any default, yes, we have discussed any default made in complying with the requirement of this section, company and every officer who is in default shall be liable to the penalty of 1,000 rupees per day. Maximum penalty is 1 lakh rupees. So if the registrar has reasonable cause to believe that the company is not carrying on any business, company is not carrying any operations, so he may cause a physical verification. He may come to register office, physical office, physical verification. And if any default is found to be made in complying with the requirements, then he may, without prejudice to the provisions of this section, initiate action to removal of the name of the company from the register of companies under chapter 18. So suppose if registrar believes that there is no business, he will come and he will check physically. Then if it is registered office not there, then he can remove. He has the power to remove also the name of the company from the register of companies. This is what about the section 12. Then section 12, subsection 8. Hope we are clear. We have discussed in detail for the registered office. We have 2 channels, RR Corporates and RR Legal Talks. Please do subscribe not to miss any of the latest updates. Thank you.